Hello everybody, I'm Jeff Simkovic from Billings Legal, here to talk to you about my thoughts on criminal law in Montana. Though no one wants to be forced to defend themselves against criminal charges, the fact is that people from all walks of life do find themselves in that position. Fortunately, an effective defense can help the accused criminal defendant achieve the best possible resolution of their case. Now, there are immediate consequences to being charged with a crime. Though the court cannot impose punishment on a criminal defendant who has not yet been found guilty or otherwise entered a guilty plea, the court is permitted to impose conditions on criminal defendants awaiting trial. In cases where alcohol was involved in the offense, like in the case of a DUI, it is not uncommon for the court to order the defendant to abstain from alcohol and to require regular testing of the defendant to ensure their compliance. The court may also require a defendant to not communicate with witnesses or alleged victims of the crime. These conditions are typically set at the time of the defendant's initial appearance in court, which is also typically where the court receives the defendant's initial plea. In most circumstances, it will be in a criminal defendant's best interest to plead not guilty at the time of their initial appearance. A criminal defendant also has a right to review the evidence that the prosecutor may use against them. This is called the discovery in your case. It is important to carefully review the discovery in your case, as it may reveal factual inconsistencies in the prosecution's case. Reviewing the discovery in your case may also help identify deficiencies in the law enforcement's handling of your arrest, which may serve as a basis to ask the court to prevent certain evidence from being used against you at trial. If evidence is suppressed, the charges are suppressed. If the charges are suppressed, the charges are dismissed. Sometimes it takes a hearing, but that's how it's done, folks. It's also important to consider that many criminal defense matters are resolved pursuant to a negotiated plea agreement. Though a plea agreement often requires the defendant to admit to some wrongdoing, the plea agreement may allow you to admit guilt as to a lesser charge or receive a more favorable sentence than what might be imposed after a trial. Additionally, plea agreements can help keep the cost of representation to a minimum, as it is very costly to proceed to trial, often 3 to 4 times the initial retainer. And an attorney can help evaluate the discovery in the case and assist you in determining whether it is in your best interest to proceed to trial or to negotiate a plea bargain. And to that end, I'll be happy to give you a free consultation if you call me, Jeff Simkovic, at Billings Legal, 248-7000. Thank you.